The first argued case, CTIA versus City of Berkeley.
Thank you, Your Honor. May it please the Court. Theodore Olson on behalf of the Cellular Telephone Industry Association. I would like, with the Court's permission, to reserve 5 minutes for rebuttal.
Okay, the clock counts down, and keep track of your time.
Thank you, Your Honor. Berkeley's cell phone ordinance mandates an alarming point-of-view cell phone safety warning intended to change consumers' behavior that is squarely contrary to science, facts, and the FCC's carefully considered findings that cell phones sold in the United States are safe to use. The Federal Communications Commission has carefully tested the cell phones that are sold in the United States and set energy levels with respect to those cell phones 50 times below any possible thermal effects on laboratory animals.
Well, but thermal effects are not the only possible effects. And I heard you say that the science doesn't support this. Well, as we know, the science at this point is somewhat indeterminate. And as I'm sure both sides also know, there was a report that came out in May of this year suggesting that perhaps the RF radiation does have some effect adverse beyond warmth. But I'm not sure this is about science.
This is not about science.
So please don't emphasize that there's no scientific basis if this is not about science.
Well, the reason that I say so, Your Honor, is that the warning that Berkeley's message, its opinion, communicates, contains the word safety repeatedly, and it uses the word radiation, which the Federal Communications Commission said may be a confusing term to confuse ionizing radiation with radio frequency radiation. And so we have to look at what the Berkeley's message that it wishes the cell phone retailers to convey versus the facts.
But counsel, you started by, forgive me for interrupting, I thought you were done. You started by saying this is a cell phone safety measure. This case is about a cell phone safety measure.
Well, what I'm reading from the Berkeley Ordinance. It says the City of Berkeley requires that you be provided the following notice to assure safety. It later refers to use your cell phone in a certain way in order to use it safely, and it contains the word radiation. Now, Berkeley, this is confusing because Berkeley, what the FCC says, Your Honor, with respect to its findings, with respect to cell phones used in the United States, is that they are safe. Safe. What Berkeley's message conveys, the warning, watch out. If you don't use them in a certain way, they won't be safe.
Well, it communicates that when the FCC reached that conclusion about safety, it did so under a certain set of parameters, right? A certain distance.
Yes. Well, but the FCC also specified, and we've pointed this out in the brief, that the FCC requires the cell phones to be tested at maximum strength, at maximum duration, and even under those circumstances, they have to meet the SAR limitation, the absorption limitation, and that is 50 times below there could be possibly any thermal effects of the radio frequency radiation. Now, Berkeley says that it's not...
Now, you again referred to thermal effects, but of course that's not the only possible effect.
Well, that is what the FCC has determined, Your Honor. So the FCC has exclusive jurisdiction over the testing and sale of these devices. The FCC has made that determination. So the cell phones are safe according to the government agency.
I'm not sure you took my point. You're saying that 50 times with respect to thermal effect. We know that, and this is beyond any question, that this sort of RF radiation does produce heat. I mean, that's the theory behind microwaves and so on.
Correct. And that is.
I wasn't quite finished.
Yes.
But there's another possible effect from radiation. For example, it may be that there's cancer. We don't know. There is some now suggestion in the science that at some rate, as to male rats, maybe, but I don't think you can confine your argument merely to describing thermal effects as to the possible effects as to which the FCC is requiring information be provided to the consumers.
I respectfully disagree, Your Honor. I think that the FCC has said that non-ionizing radiation produces thermal effects, and that is the only damage that can come to them. Yes, people can write papers.
I disagree that that's what they've said.
Well, I respectfully disagree. But, as you pointed out, Berkeley has said we're not taking sides in the scientific debate. That is not the justification we offer. They're not making a claim that this is necessary for safety, and yet safety is all over the warning. Berkeley specifically says that we want to rely exclusively on the FCC regulations with respect to what they require. We've pointed out that the FCC regulations do not require discussion of safety. They do not require what the Berkeley Ordinance is all about. And basically, you have got to consider this is a burden on speech. And as this court decided in the retail digital case just 15 months ago, there's a very high standard that Berkeley has to come over with respect to justifying its ordinance. This ordinance is the same as described in the retail digital case.
Counsel, it's not. It's not. Can you, right at that threshold again, forgive me for interrupting, but by relying on that case, you're talking about restrictions on speech as opposed to compelled commercial speech. So right from the get-go, I've got a problem with the analysis.
Well, the retail, in the paragraph that I would refer the court to, the court, first of all, we're starting with the fact that this is a restriction. When you are, and the court specifically cites the Sorrell case from the United States Supreme Court, that burdens on speech are the same as bans on speech. They must be subjected to the same rigorous standard. That's a Supreme Court decision quoted in the retail digital case just 15 months ago, because this is content-based, a content-based measure. It's content-based, it's viewpoint-based, and it's speaker-based, and it is with respect to non-deceptive speech, with respect to a lawful, safe product.
Could I take you back to this issue of whether the warning conveys a message that carrying a cell phone in your pocket is unsafe? If I agree with you that it conveys that message, I think I'm disagreeing with what the district court thought, because the district court seems to have thought that this message was entirely factual, entirely true, and did not convey a message that there's a danger here. What standard of review do I use to review that district court determination?
Well, we believe that, and we submit that this is a de novo, because what the district court was doing was interpreting the words of a statute. And as this court decided in the San Francisco case, which of course, as you know, involves cell phones and safety warnings and that sort of thing, same sort of issues, this court in the San Francisco case construed the words of the statute and said they might possibly.
It wasn't published, though, so we really can't rely on that. So do you have any published authority for the idea that we can interpret this de novo, even if the district court has done otherwise?
There are cases interpreting a statute is a matter of law, and it's something for an appellate court to review de novo. Interpreting this statute, which is an ordinance, is the same sort of thing. And what the San Francisco court, it may not be binding, but it is somewhat instructive. The court may consider it. The court there said that the warning in the San Francisco ordinance might possibly be construed by consumers as suggesting a warning about safety. There's a reason why Berkeley put the word safety in here. It's intended to send an alarm.
Was there any expert testimony or consumer surveys or anything to support the district court's conclusion about what this meant, or did the district court just look at the language and decide what it meant?
I believe that's what the district court did. There was a survey conducted by Berkeley for various different reasons, which we point out in our briefs.
But it wasn't about the interpretation of what this meant, as I read it. It asked other kinds of questions.
I agree with you with respect to that. And I do believe that there's no question. It comes down to this, it seems to me, that this is non-deceptive speech that my clients are engaged in about a safe product. It's commercial speech. Berkeley's ordinance, no matter what you think of it, is based upon the content of the speech, the viewpoint of the speech. They admit that this is hortatory. hortatory, intended to persuade, intended to change or possibly change the conduct of consumers. It is a message. It's an opinion. It is not a disclosure. Berkeley repeatedly states in its brief that it's just a disclosure regulation. It is not a disclosure regulation. It is a point of view.
Well, let me oh, go ahead, please.
Look, please. Why isn't it a disclosure?
It doesn't require a disclosure of the contents of a product like alcohol content or salt content.
Well, it's disclosing. Why isn't it disclosing? Opposing counsel would say it's disclosing that here's what the parameters were when the FCC reached the conclusion that this product is safe. Why isn't that a disclosure?
It does it falsely. It misleads what the FCC has decided. It misleads what's in the manuals themselves.
What's false? What's false?
The false is the message, just like the San Francisco case, the message is if you don't be careful, you might exceed these guidelines. You're going to be exposed to...
That's true. If you're not careful, you will exceed the guidelines.
But if you do exceed the guidelines, the cell phone is still safe. The FCC has said that, and we've repeated the exact language from the FCC saying exceeding these guidelines, the cell phone is still safe. The message that Berkeley is conveying, it's an opinion, it is a message, it takes a point of view, and it suggests to you, if you don't be careful, you have an unsafe product. Now, I want to make sure to reserve the balance of my time for rebuttal.
Well, let me ask you a question first, and we'll make sure you get a chance to respond to the other side, even if we take you over time, so
Thank you,
don't worry. I'm just reading from the relevant guideline by the FCC. It says, specific information must be included, so it's mandatory, in the operating manuals to enable users to select body-worn accessories that meet the minimum test separation distance requirements. Users must be fully informed of the operating requirements and restrictions. All supported body-worn accessory and operating configurations must be clearly disclosed. Now, that's what the FCC says.
It isn't what the FCC says. That's what an agency of the FCC says, and what the FCC says.
So, well, let me stop you right there then. So you're saying this guideline has no force and effect?
That's exactly right. I refer you to, Your Honor, 47 CFR, and this is cited in our briefs, 47 CFR, section 2.109D3, which specifically says the staff guidance provided in the KDB, that's the thing that you're referring to, is not binding on the Commission or any interested party. The same is true in the FCC document called reassessment in section paragraph 234 and 247, the latter of which says the OET Bulletin 65, which you've just quoted, including its supplements, is not mandatory.
So Berkeley argues in their reply that CTIA waived the idea that this wasn't required. What is your response to that?
We said right from the complaint, I think it's paragraph 65 in the complaint with respect to that subject, we made arguments again and again in our opening brief and in the lower court that these are not binding requirements. At the end of the day, it would be pretty difficult to waive what is in the law, what the FCC actually says is the law. So
am I right, though, even if it is binding, your main argument, I think, is that the warning conveys a different message than what the requirement is anyway, right?
That's exactly correct, Your Honor. And unless there are further questions at this point, I would like to reserve the remainder of that time.
Yes, and we'll give you, you'd sought to reserve 5, so we'll give you a little more than you've actually saved.
Thank you so much.
Good morning, Your Honors. Lawrence Lessig, representing the City of Berkeley. The Supreme Court has heard the arguments that Mr. Olson has made here today. Maybe not as eloquently, not as powerfully, certainly not with as beautiful a suit, but it has heard them at least twice, and it has rejected them at least twice. In Zauderer, it rejected them the first time. Like Mr. Olson, Philip Zauderer argued that the same First Amendment standard should govern both restrictions on commercial speech as disclosures that are mandated for commercial speech. Justice White rejected that idea. In that case, like Mr. Olson, Philip Zauder argued that the idea that Barnett and Woolley somehow provided support for the notion they had a right to remain silent. Justice White practically chuckled at that idea. The interests at stake, he said, are not of the same order as those discussed in Woolley or Barnett. Instead, in that case, Justice White...
Even if we assume that Zauderer is the standard, would you acknowledge that the message conveyed by the warning has to be true, factually true, for it to survive Zauderer?
Absolutely, Your Honor. And
so if I read this warning and I think it conveys a message that putting a cell phone in your pocket is not safe, how do you respond to that? Because it seems like at that point I have to strike it down under Zauderer, don't I?
No, you don't.
Why not?
First, though CTIA has repeatedly said in their reply brief and here today that the FCC has stated that a cell phone, regardless of how you hold it, they say, for example, no matter how carried, on page 1 of their brief, or, quote, regardless of how it is held, the FCC has never said that. The sites that they give you are two. Number one, a web page, which never says that regardless of how you hold your cell phone, it is safe. All it says is cell phones are safe, but safe because they are limited in the amount of RF energy that they produce. And that web page...
Okay, well, let me put it the other way. So I think this warning suggests that it is, maybe I said this already, unsafe. Not that we know it's safe, but that it's unsafe to put it in your pocket. And I didn't read your brief to try to support that proposition. I mean, maybe I'm misunderstanding, but it seemed to me you were saying we're not arguing about the science, we're not arguing about the health, and you seem to be defending the truth of a different proposition. But if I read it to say this is unsafe, then you haven't really taken a position that that's true, have you?
No, that's right, because Berkeley's position is we have the right to legitimate state interests for us to rely on FCC safety regulations. And FCC repeatedly refers to RF energy limits as safety regulations. And all our ordinance says...
Call them safety regulations, but have they ever said putting a cell phone in your pocket is unsafe?
No, but they have repeatedly said, here are the standards you have to live under in order to get a cell phone approved so that we can certify it as safe. And then the question becomes, the second part to the response to your question is, what is the standard that this court must be applying in evaluating how you might interpret what Berkeley has done? Certainly, if this were heightened scrutiny, then you should pull out your red pen and should ask the question, could we craft this ordinance in a way that was clearer, slightly different? But this is not heightened scrutiny. That's what the Supreme Court has rejected twice. And when
but what is the standard for interpreting the language?
Yes.
So, I mean, there's a question about whether there could be a less restrictive alternative, but just in terms of interpreting the language, did the district court do anything that is better than what we could do? I mean, was there a factual hearing about what the language meant with consumer input or anything like that?
No, there was not a factual hearing because all CTIA did in response to the argument that this was not misleading, that it was factual, was make lawyers' arguments that it was not factual, that it was misleading. And what the district court did was to look at the facts and evaluate the standard on the basis of his understanding of what it meant. Now, it is an open question, I think, after Zauderer, after Milovitz, how a court is supposed to evaluate the factual standard.
Forgive me, but you just keep almost, but not quite addressing what I'm trying to get at. Are you speaking now of how, when you're talking about interpretation, are you speaking now of how a reasonable consumer might interpret, how the district court was to decide how that would be interpreted on the receiving end?
Yes, that's the open question.
Right. What did he have? That's what I think Judge Friedland's trying to get at, and I'm waiting for somebody to answer that question.
Yeah.
What did he have to decide that?
He did not have surveys. He did not have interpretations of consumer surveys like in a trademark case or like in a defamation case. But again, what I'm suggesting is the court has not yet articulated exactly how that inquiry should be made. Every time the court has looked at the factual standard, it is interpreted just as judges would interpret it. And so the question is, are the facts true? These facts are true. What Berkeley has said is there's an implication here that this means that the cell phones are unsafe. And they've said that conflicts with the FCC's explicit statement that the cell phones are always safe. But our position is FCC has not said that. I just want to make sure so that when Mr. Olson responds to this, we have all the facts before us. They repeatedly point to paragraph 251 of the reassessment. This is their favorite paragraph. 252 of the reassessment is directly contrary to what 251 says. In 252, what the FCC says is, quote, given the considerable safety margin in our requirements, would the potential number of occurrences, and by occurrences they mean instances where you're not adhering to the SAR standards, resulting from inattention to manual instructions and the extent of resulting exposure constitute a health hazard. Now, the FCC would not be asking for comments about whether there's a health hazard if it had concluded that there was no possible way that a cell phone held against the body could constitute any health hazard. So the premise of their argument that this is misleading is just not supported by the record that they've given you.
It seems like there's a really interesting question of whether you can do a warning when science is ambiguous. But I don't interpret this case as really being litigated that way, because it seems like your position hasn't really been that the science is ambiguous, so it's okay to be extra cautious. You haven't really, you said the science doesn't really matter. So if we interpret, I mean, and I may not, my colleagues may not agree with me, but again, like if we interpret this warning to actually be making a statement that it's unsafe, I don't see you to have defended that. And so this really interesting question of what we do when science is unclear, I'm not sure we're there. It seems like that's like if Berkeley tries again and we're in the next case. Because they've not defended it that way, have they?
No, because our position is that we are relying on a regulation of the FCC. We don't want to get into the argument about the science. We don't think we should have to get into the argument about the science, not because it might be clear or not clear, but because the standard of review says we should have the right, as 5 circuits have said, to essentially a rational basis review, so long as there's a reasonable relationship between the legitimate interest and our regulation.
But all of those cases say the statement has to be true, right? Or assume that it has to be true?
Right, and these statements are absolutely true. The only thing that's been alleged is that there's an implication from these statements that conflicts with what was said to be a statement by the FCC, that these are always safe no matter how they are used against the body.
Let me go at it this way. It seems to me that the Berkeley Ordinance, if we simply look at it in terms of logic or construction of language, is of course absolutely true. And the FCC has got safety measures. Now, their safety measures are extremely conservative or cautious. That is to say, the margin of safety is enormous, as the FCC itself says. And when the Berkeley Ordinance says to assure safety, that's exactly what the FCC is doing. So I got that part. So in that sense, it's absolutely true. But I also think it is a fair inference from when the language starts out to assure safety that if you don't do this, it might well be unsafe, otherwise we're not going to give you this warning. So the question is one of tone or perhaps implication. How do you respond to what I think is just a commonsensical reading of this language? I read that language and say, uh-oh, I'm in trouble if I put it in my pocket. Right. When in fact I may not be in trouble at all.
Right. And if there were a proper First Amendment interest triggered here, then this court could pull out its red pen and rewrite California's legislation. But the whole point of the argument, as I began, was to say the Supreme Court has said there is no proper First Amendment interest here that gives you the right to apply heightened scrutiny, and you can't pull heightened scrutiny in to the factual analysis.
I'm not talking heightened scrutiny, I'm just trying to understand the language and what it reasonably conveys to a reasonable consumer.
Right. And, Your Honor, we could imagine 30 ways that we could rewrite the language. And my point is, the power of this court.
Yeah, but I'm not even trying to rewrite the language. I'm trying to understand the language as it is written, and there's at least a plausible argument that a person reading this is going to say, you know what, there may be a real problem, and I may be threatening all kinds of health hazards to myself if I don't do it. That's a possible reading.
That's a possible reading, you're right. And that is exactly why the FCC has mandated to require these type of information in manuals.
So what, in your view, is the wording of the FCC mandate?
Well, Well, the FCC mandate requires,
No, I'm asking you, what's the wording of the mandate?
there's no particular wording. What it requires, according to,
No, not the wording that they require, that the cell phone people require. What is the FCC wording? What are the words the FCC uses?
well, when the FCC imposes this requirement, which they do indirectly through the telecommunications bodies, which certify the process of devices, what they say is, quote, end users must be informed of body-worn operation required satisfying RF exposure compliance.
And
So
they
what-
don't give specific language, right?
No, they don't. But my point is, why are they doing that if there's no possible concern about safety here?
But so this regulation, this warning could say the FCC sets radiation levels they do that assuming you won't have a cell phone in your pocket. If it was just that statement, I would think it was true and it would be fine. But I don't read your warning as saying that same thing. I think it goes beyond that. And so this is where I'm really struggling with how to call those equivalent.
Well, it certainly goes beyond that, because what our survey discovered was that people had no recognition that there was any issue here, because they didn't even know that there was a testing regime that tested away from the body. So we go beyond that
Right, so
in order
your
to
warning could say when the FCC tests cell phones, it assumes they'll be away from the body. That would be factually true.
That's right. But the point again, I'm sorry to be so stubborn about this particular point, is what is the jurisdiction to be quibbling with the precise language if there is no heightened review?
Yes, but your argument is circular, counsel, because you're clinging to the standard of review, of course, but that's all premised upon this being accurate, factually accurate.
Right. So if
And that gets us to the I think, difficult question about how this warning is likely to be perceived by the public.
That's right. And if you import into that question of the factuality of the statements heightened review, then that's inconsistent with what Milovich said. It's inconsistent with what Zauderer said, because in both cases the question was raised, should there have to be some evidence to establish any of this? And the court said, no, this is, as 5 circuits have said, essentially rational review. So the other point...
In Peel v. Attorney Registration and Disciplinary Commission, it's a 1990 Supreme Court case, the majority said that whether the inherent character of a statement places it beyond the protection of the First Amendment is a question of law over which the members of this court should exercise de novo review. And that was responding to Justice O'Connor saying that we should defer to a government's reading of how a warning would be allowed or how a statement would be read. I mean, that was the case that I could find that was most closely on point. Do you have a response to that case? Is it one that you looked at?
No, but again, Your Honor, I'm happy to agree that there's a suggestion that there's a safety issue raised by carrying a cell phone against your body. I'm happy to agree with that. But the point is, that is not rejected by what the FCC says. There's no long line of science that says there's no safety issue here to worry about at all. So the problem with suggesting that is what I'm saying I don't understand. The suggestion of that is perfectly consistent with the reason the FCC has for mandating information about whether this is going to be held. But the more fundamental point, and I want to make sure before my time is expired to emphasize this. This is a point made, I think, powerfully by NRDC and the state of California. If you imagine a standard where every time a jurisdiction tries to issue a mandatory disclosure warning, they've got to come to a federal court and prove that, in fact, the risk is as significant as they say, then that's effectively a way of guaranteeing that there will be no such regulation. If you think about But
they could, maybe the standard is just that they have to show that there's some risk. But I don't think you have really litigated this case on the basis that you're showing that there is some risk. So, I mean, I thought it was interesting. I thought perhaps those parties would have filed briefs on the other side saying, our warnings are really based on risk, and we don't want this dilution, this, boy crying wolf problem.
Right.
They actually filed in support of you, but it seems like there is a real downside of having unsupported warnings all over the place, isn't there?
Well, but these warnings are supported by the incredible regime the FCC engages in to make sure that cell phones don't exceed RF SAR limits. So there is a basis here. This is not like a GMO claim or maybe a growth hormone claim. There's a basis here. And all we've done is to make sure that consumers are aware of this basis. And if we imagine any time there's a safety standard with a safety factor, so for example, imagine a risk conceived of at 5,000 parts per minute. per million. And as NRDC argues, many times cancer safety factors are a factor of 1,000. So that means a warning could be issued that says no more than 5 parts per million. If a company came in and said, look, we're just going to have 10 parts per million, and the standard is, as CTIA says, that, quote, the government bears the burden of showing that the harms it recites are real and that its restrictions will in fact alleviate them to a material degree, there's no possibility the government can make that showing, because by hypothesis, on the margin, between 5 and 10 parts per million, there is no effect. So this
can I ask you, is there any warning that would be prohibited under your approach?
Of course.
What would it be?
If the warning warned of something that was factually never found to have any such risk. So, for example, uttering the word Republican inside of, well, I'm not sure if that's true, uttering the word Democrat inside of a courthouse in California, that would present no risk. There's no basis on which to find it. But of course, the FCC is quite strict in its efforts to make sure, and we have cited in our brief
Is that really your argument? They would have to show no risk ever, as opposed to at some point, couldn't a notice be sufficiently misleading?
Yeah, and
Is that
again,
really your argument? It would have to be.
Yeah, Your Honor, and we're happy to say that if the FCC had come down and said there is no possible risk from a cell phone being held in the pocket or anything, if they had said that, then yes, suggesting there's a risk would be misleading.
But you're not answering my question. You're not answering my question. Isn't there some point at which a notice could be factually accurate, but sufficiently misleading that we would be in this, that we would have this problem? I fully appreciate you think you're not there, but now it seems to me that you're suggesting that there's never a time that could happen. And I just want to be really clear about that.
No, I'm not suggesting that. That's why I was giving you a hypothetical under our case
It had
where
something to do with Democrats or Republicans. You lost me completely. I don't know what that was. But I'm not trying to be glib, counsel, but I think your point on this is quite important, at least on my scorecard.
Yeah.
So could you please clarify?
Right. So what I'm saying is, if the facts point to something that's clearly misleading, I'm happy to concede that, yes, there's no longer factual. That is the basis on which Zauderer and Milovitz decide. So I was giving you a hypothetical related to our case. I said that if the FCC had said plainly that cell phones are completely safe, wear them against your body, do whatever you want with them, there's no risk, and we suggested there was a risk, that would be misleading. And if it's misleading, it would not be factual. And if it's not factual, it would not fit within Zauderer and Milovitz. But what I'm saying is the premise to that argument, which they've made in their reply brief and again here, is not supported by the record they've cited. So there is, in fact, a question. The FCC is careful. And that's why the FCC has continued the proceedings to ask these questions about what that risk is. And our position is, as a jurisdiction, we should not be forced to engage in the science. We should be allowed to rely on the FCC's judgment that there's a safety issue here, which they call it, which they are regulating by making sure there's no exposure beyond a certain limit, and which they are constantly monitoring cell phone companies to comply with. That we should be able to rely on that in order to regulate without facing the burden of a First Amendment challenge that would strike it down.
Okay, thank you very much.
Thank you.
Mr. Olson, we allowed Mr. Lessig to go over time. Why don't we put 5 minutes on the clock for you?
Thank you, Your Honor. Very much
And before you begin, I would like to say the beauty of your suit is irrelevant to my evaluation of your argument.
Thank you for that also, Your Honor. With respect to the standard of review, the video software case discusses this on page 967 and calls for de novo review. There are lots of other cases. This is a First Amendment case. This is a matter of interpreting the words of the statute and what a reasonable consumer might possibly
That part I think is really uncontested, but I think we're trying to get at a different question about what do we do regarding sort of reviewing this notion about how a reasonable consumer would or would not interpret that notice, Counsel?
I think that is the responsibility of courts, and it's a burden of the government to prove the various factors, because that leads directly into the standard of review.
what's your strongest argument? You said very forcefully first time around that this is false and misleading. What's your strongest argument it's false?
Because my strongest argument is that the word safety appears twice in the ordinance, the language itself, the warning. It appears 5 times in the findings that went with Berkeley. It contains the word
But in terms of what goes to the consumer, they read the word safety twice.
They read the word safety, but you have to look at what Berkeley intended, and that's in their findings.
But I thought the question went to the effect on the consumer rather than what Berkeley intended.
Well, that's right. But it also contains the word radiation, and we've quoted the point where the FCC specifically said radio frequency safety asks questions. The term radiation is often used colloquially to imply ionizing radiation, radioactivity, and these terms can be confused. Now, Judge Chen said, no, there's no possible way that anyone could confuse that. That's directly contrary to what the FCC says. So the total effect, Your Honor, is watch out. Whereas the FCC is saying, and you asked this question too, what did the FCC, has the FCC said? And these are citations from the brief, quote, currently, no scientific evidence establish a causal link between wireless devices use and cancer or other illnesses. It also says there are no link between cell phones and any known health problems. It also says the FCC's SAR limit is 50 times below the threshold where RF energy is shown to have an adverse biological effect in laboratory animals.
So
that's what the FCC has said.
Right. It seems to me your strongest argument is not that this notice, this required notice, is false. I think your strongest argument is, if I'm understanding it correctly, is that you think people are going to be misled because they're going to be frightened. They're going to see the word radiation and they're going to freak.
Because they're going to get a false impression. If we
that
turn,
right? That's
correct.
the strongest argument?
Well, it is a part of the whole, but if you turn to the Zauderer case, which we don't think, and we submit is under retail digital and the Sorrell case and video software, the standard is heightened scrutiny. That's the Supreme Court case, the Sorrell case.
If Zauderer requires truth, and your argument, whether we call it falsity or misleading impression, either one, Zauderer requires it to be neither of those, right? So do we need to decide whether it's Zauderer?
You do not. But Zauderer does require it to be purely factual and not controversial. Now, what was wrong with what...
I'm not sure the controversial survives the later Supreme Court case.
Well, I believe it does. In the Melovets case, it's repeated again. And by the way, that term deceptive is repeated in digital software case.
I referred to controversial, not the word deceptive.
Well, and I think it's still there, but the Supreme Court hasn't taken it out yet. But I want to refer back to Zauderer, because even if that was the standard, this ordinance is unconstitutional. What was wrong with what the attorney was saying in Zauderer? The attorney was making advertisements with respect to contingency fee services. What was found to be deceptive about that, false about that, misleading about that? The attorney didn't say in the ad that, well, you might have to pay fees or facts.
Costs, right? Costs.
Expenses. So it was misleading because statements necessary to make it not misleading weren't made.
But it was factually true on its face. It just was misleading.
But that's a different
misleading
problem.
by omission.
It was an omission. So in this, and I appreciate you raising that, because as I understand it, there's nothing that prevents your clients from adding information to this notice. What about that?
Well,
what about the fact that I think that allows your folks to say, hey, there's never been a finding.
Well,
cell phones
that
are
is a
unsafe.
significant burden on speech, Your Honor. When you're putting someone in a position saying, if you want to make a statement, speak, you must also face the possibility of repeating someone else's message, the government's message, and either acquiescing in that through your silence, or you have to get into the debate in the marketplace, which you have chosen not to get into.
Would your clients, this is a legitimate, a sincere question, would your clients be permitted to add a sentence at the top of this that says the FCC has never found that cell phone usage is unsafe?
As far as I know, under the ordinance, there would be no prohibition of that, but it forces the debate on a subject that our client wishes not to get into. The manuals and what the FCC, it's false. It's both misleading by omission and it's false because it gives the wrong impression. The same thing that San Francisco's ordinance test that San Francisco ordinance failed. It says safety. Think about safety. Think about how you use your device, or you might not be safe. And the FCC says safe. Berkeley says watch out. The digital software, I mean the retail case, digital retail case specifically says if it is non-deceptive speech in commercial speech about a lawful product, and if it's content-based or viewpoint-based or speaker-based, they're all pretty much the same thing here, and Berkeley fails all of those tests. You have got to apply heightened scrutiny, and then Sorrell is saying burdens and bans are the same.
You're now well over the extra time we gave. Any further questions from the bench?
Thank you for your indulgence.
Thank both sides for their arguments. The case is now submitted for decision, and we'll take a 10-minute break in order for the camera stuff to get broken down and things to get rearranged.